The Agenda with Steve Paikin is made possible through generous philanthropic contributions from viewers like you. Thank you for supporting TVO's journalism.
Tonight, is Canada's bail system failing? Then, the plight of stateless citizens. Happy New Year, everyone. That's all next on The Agenda. Canada's bail system is once again being questioned following the shooting of a police officer in Ontario's capital city last fall, where the accused was out on bail at the time. The Ontario government has called on the feds to get tougher on repeat offenders, while advocacy groups have raised concerns about overcrowding in provincial jails. Joining us now to discuss what reforms are needed, we welcome James Maloney. He is the Parliamentary Secretary to the Minister of Justice and the Attorney General of Canada. He's also the Liberal MP for Etobicoke Lakeshore. Shakir Rahim, a lawyer and director of the Criminal Justice Program at the CCLA, that's the Canadian Civil Liberties Association. Mark Baxter, president of the Police Association of Ontario, and Nicole Myers, criminologist and associate professor in the Department of Sociology at Queen's University. And let me just start, since this is our first program back in 2025, by wishing everybody a Happy New Year. Thank you for coming in all the way from Kingston. Indeed, very nice. And I'm happy to see you today because I've heard there are some other things happening in the nation's capital today, and yet you're a Liberal member of Parliament and you're here. So we thank you for fulfilling your commitment to us.
My pleasure. I'm focused on the task at hand here, Steve.
Gotcha. The Canadian Civil Liberties Association, Shakir, your organization, and Education Trust released a report early last year to assess the current landscape of the bail system. And here are some key points. Let's get this graphic up and I'll read along for those listening on podcast. 80% of people in Ontario jails are in pre-trial detention. 80%. It costs Ontario more than $400 a day to detain an individual. The constitutional right to a timely bail hearing is often violated due to court delays. The number of people in pre-trial detention across Canada has surpassed in-custody counts prior to the pandemic. And there is still, as you may not be surprised to hear, mass incarceration and overrepresentation of Black and Indigenous people in the criminal justice system. Okay, Shakir, get us started here. What prompted the CCLA to conduct this study on the bail system to begin with?
Well, this was a follow-up on our 2014 report on the bail system, where we observed many of the same trends. And one of the main reasons that we published that report and this report is the degree of misinformation and misunderstanding about how the bail system in Canada is operating. And as the statistics that you just raised point out, the reality of the bail system is quite different than what we might read in the headlines. And the numbers you cited, well, I think there is a narrative that has taken hold that we have a lenient bail system, one that lets people out left, right, and center. But for example, in 1982, it was around 23% of people in provincial and territorial prisons that were in pretrial detention.
Now it's 80.
Now it's 80% in Ontario.
What does that tell you?
So it tells us that we have the opposite of a lenient bail system. There's always room for improvement. We need to care about public safety. But what we see right now across Canada, especially with overcrowding in remand facilities as well, is not a situation where bail is simply too easy to obtain, but actually quite the opposite.
Let me follow up with Nicole on that. The report, I believe, is called Still Failing. This follow-up report, Still Failing. That's a tough title. Do you agree with it?
I do. I think that we do have a system that's facing a whole lot of difficulties and failing in many ways, but it may not, as Shakir just indicated, it's not necessarily failing in the ways that were commonly talked about. So we think then about sort of these relatively rare but incredibly tragic incidences that garner our attention and are deeply concerning, and we need to worry about those. But when we then focus our attention on there without the context of what's going on, we miss that we incarcerate more people who are legally innocent than have been convicted and sentenced to be there. And so what we're really having people do is we're going, you're innocent, but we're going to have you serve a sentence. And we're going to have you do that on the front end of the system. And this is happening to thousands and thousands of people. And so while we may recognize that tragic things happen and maybe some decision-making needs to be different in those individual cases, we can't forget to sort of put that into the context of acknowledging that these are people's legal rights. You have a right to be presumed innocent until you've been proven guilty. If we want to sanction people, we want to punish them, hold them accountable for what they've done, we need to convict them first.
Mark, where are you coming from on this?
Yeah, certainly we have a system that needs to continue to be evaluated, and that isn't working, and it's not working for Canadians. It's not working for our members that we represent. We're continuing to see far too many offenders arrested for violent repeat offenses that are back out on the street committing an offense the next day and re-victimizing the folks in our communities. And what our members, are dealing with on a day-to-day basis, and what they're hearing from the community is, we're arresting someone for a violent offense. We're arresting someone who continues to breach conditions, that continues to re-offend and victimize the community. We arrest them, we charge them, they're back out on the next day, committing the same types of offenses, and it's becoming a real problem. And we're getting, the result is folks in their communities are really starting to feel unsafe.
The thinking on this side of the table is that 80% of the people who are in provincial jails right now are technically innocent, right? They're innocent until proven guilty, which is a very high number compared to several years ago. What's your take on that?
Yeah, my take is that stricter policies for repeat and violent offenders isn't about punishing the innocent. It's really about striking a balance of protecting and safeguarding people's rights, but also protecting our communities and ensuring that folks, they do have a right to bail, and there are certain rights that go with that, but we've got to carefully balance that with the safety and the security of our communities. And that's where, this system continues to be failing our communities, and we need to continue to reassess, and we need to make some changes.
James, I wanted you to have a chance to listen to all the other wisdom at the table before you weighed in. How do you think it's going so far?
Look, I mean, the problem is one of the big problems I see it is there's rhetoric out there that distorts the perception of the reality. Because, I mean, everything I've heard right now is true. All five of us here in this room, and everybody I know, wants a safe community. I want my neighbors to feel comfortable. I want to feel when I go home I don't have to worry about some of the things we're talking about. The problem is there's so much political rhetoric out there right now that it distorts the reality. There's a capacity issue. I mean, governments need to work together. All of us need to work together. That's where this discussion needs to focus, in my opinion, because right now you have provincial governments pointing at the federal government. You have different organizations pointing at the federal government as if the laws are all the problem. The bail laws are not the problem. That's not to say there isn't room for improvement. The problem is there is structural integrity problems with our system, when it comes to Crown attorneys, when it comes to penal institutions. In my riding of Etobicoke Lakeshore, my constituents are concerned because the West Toronto Detention Centre is way over capacity. And what does that mean? It means people who are getting out on bail, who shouldn't be getting out on bail, because for two reasons. There's not enough Crown attorneys to process the bail applications, and there's not enough capacity in the prison to put them in because the conditions are inhumane. And that's not my language. That's language that comes from judicial renderings, judicial decisions that have been released in the last few months.
And those are both areas that the provincial government has carriage of.
Absolutely.
So in your view, if there is a problem with bail right now, it's because Queen's Park isn't acting enough.
Look, I'm not going to say it's one person's fault or the other. I'm going to say it is not constructive when you have provincial politicians going on Twitter and having press conferences every time there's a sensational crime and blaming the federal government for the bail laws, because that is factually not the case. There's a capacity issue. There's a structural integrity issue. You speak to Crown attorneys and they will tell you they don't have the capacity to conduct all these bail hearings. We heard data talked about. We need data desperately, because right now in the province of Ontario, we have no idea what the process is or how these things play out. So whenever we hear a story about a crime being committed and the person's out on bail, the next question that should be asked is, why did they get out on bail? What were the circumstances surrounding their bail hearing? Was there a bail hearing? And if there was it appealed? I mean, but we don't have that information, and the province isn't forthcoming with it, and that's part of the discussion that needs to happen, and we need to sit down at the table, all of us. I'm willing to sit down with the provincial representatives. Minister Varani has invited on more than one occasion.
He's the Minister of Justice.
Minister of Justice, our provincial counterparts, to sit down and let's have this discussion, but they're not willing to do it.
Well, I don't know if two of the people that you were referring to in that last answer about calling press conferences every time something bad happens, but there were two out of the provincial cabinet that we did invite to be with us here tonight on the program, and for whatever reason they declined our invitation. That's the Solicitor General Michael Kersner and the Associate Minister of Auto Theft and Bail Reform, Graham McGregor, who has direct access to this file, obviously. Here's what we can do. We can put this letter that Kersner, the Solicitor General, sent to the federal government and made public on the record here. And here are a couple of things that he has in mind. Can we get this graphic up, please? Restoring mandatory minimum sentencing for serious crimes, and then removing bail availability for offenders charged with some particularly egregious offenses, for example, murder, terrorism, intimate partner violence, etc. Let's do a couple of more bullet points here. Introduce a 3-strike rule, mandating pretrial detention for repeat offenders, and remove credits for time served awaiting trial for repeat and violent offenders. Okay, that's coming from 2 cabinet ministers in the province, or check that, from Michael Kersner, the Solicitor General, top law enforcement official, if you like, in the province. What do you think of those options?
Yeah, I think it shows, we need, as you've said here, we need all levels of government. We need everyone to come together to find some solutions. And it shows a willingness on the provincial government to come to the table and say, hey, these are some of the things that we're proposing. One of the things that we have right now that when you talk about, the 80% of folks in custody are awaiting a trial, part of our problem now is we have a system that in many ways incentivizes folks to stay in custody at times. Because if they are planning on pleading guilty, or they know that they're guilty of what the offense that they've been accused of, they're going to get additional credit for staying in custody. And so, oftentimes, and I think a lot of people don't realize this, but oftentimes folks will get 2-for-1 credit for time they spent in custody before their trial.
So you like getting rid of the credit?
So the credit needs to go. In terms of minimum mandatory sentences for our most serious offenses, I don't understand why we wouldn't have that, and why the federal government wouldn't entertain bringing something like that back.
Well, let's find out. James?
Look, I'll agree with Mark on the first point, but I don't agree that the provincial government has signaled a willingness to sit down and talk about this. The Minister of Justice, Arif Virani, has asked them in letter time and time again to come and sit down. You just said right now, Steve, they refused to come on the show, or they declined the invitation. That sends a very loud message to me. It means they don't want to have these hard discussions. We're here talking about bail reform. What does the letter talk about? It talks about mandatory minimum sentences. It talks about things other than bail. With all due respect to my provincial counterparts, they're not being completely candid and straightforward about this. They're playing the sensational card, and it doesn't work. They need to sit down in a room. Look, I'll come back on your show and sit down with Associate Minister McGregor. I practiced law for 20 years, Steve. I know a little bit about a little bit the program or the system. I'm more than willing to sit down with him and anybody else, and I know the minister is as well, to have these discussions, including the police and other stakeholders. But until we get past this rhetoric stage of these people having a press conference or putting out tweets and doing all this, we're not going to accomplish anything other than blaming people that in large measure don't deserve the blame.
Let me just get a little background here. This 3 strikes thing that we've heard about, this was a big deal in the States for a while. Can you tell us what that is and what the experience down south was when they did it?
Yes. So 3 strikes is sort of and it takes different formations in different places, but the idea that after 3 particular offenses of a particular seriousness, that you're going to be automatically locked away for very lengthy periods of time. And what we're continuing to see in the United States is developing a long history of mass incarceration, where they are bankrupting states by trying to pay to incarcerate all of these folks. And what the need is then to go, how do we start trying to backstep and undo? And this is what governments are now actively trying to do. They're recognizing that these kinds of policies cause harm. And part of what the harm is making something mandatory. What I would offer something that needs to be more tempered, like a structured discretion, where we can sit and have a conversation about what do we value, what do we want you to consider, how much weight do we want you to give this, and maybe even hurdles that we have to meet particular thresholds before we're going to put somebody in custody. But as soon as you make something mandatory and take away the possibility of going below that, removing discretion, we're creating the opportunity for more injustice.
Well, okay, Shakir, let me just see if I can understand this better. I suspect nobody wants to put anybody in jail here for 10 years if they stole a loaf of bread on 3 separate occasions because they were hungry.
Right.
But if you sent somebody to hospital 3 times because you committed assaults on 3 separate occasions, we might very well conclude that you were too dangerous to be out on the streets. So help us understand the context here behind 3 strikes.
Sure, Steve. I think the problem with three-strike rules is it removes the opportunity to look at unique situations and considerations. You're essentially binding the hands of the judge, and we see that that leads to cases of injustice where maybe there are circumstances we did not contemplate, even for someone who might have had, let's say, a long period between reoffending or changed life circumstances, that rule removes consideration of. But I want to just quickly touch base on 2 points that were previously raised in this conversation. The first is around what the Ontario government is asking for. Now, we've heard that bail reform is about repeat violent offenders. But in that letter, as you noted, there is the removal of bail for all offenses entirely. So that would include people who are first-time offenders with no criminal history. People like Umar Zamir, who was charged with the serious crime of murder, but we clearly saw that was a weak case and he was acquitted. And the associate minister...
Give us 20 seconds of background
on
that.
Of course, yes. Mr. Zamir was a family man out in downtown Toronto with his family. He was approached by 2 officers who were undercover, didn't know who they were, panicked, drove his car away, and tragically one of those officers passed away. But it was found that, he had no criminal intent, didn't know they were officers, and he was acquitted. Now, that's a kind of person where even earlier on in the prosecution, it was seen that that was a weak case. In fact, the bail judge commented on that. And yet, that's the kind of case with which the Associate Minister of Bail Reform has admitted their proposals would result in bail being denied for someone like Zamir.
And his life was already turned upside down pretty dramatically.
Absolutely. And when you hear about proposals like eliminating bail entirely, those clearly violate a constitutional right, Section 11E of the Charter, which grants access to reasonable bail. And so I think we have to be very careful about we hear on one hand rhetoric about we're dealing with a very small class of repeat violent offenders. But then, in the proposals that are being floated and supported by some people at this table, we're hearing about bail as a core right, which has been part of the common law system for centuries, being removed altogether.
I should just ask you, James, as a politician, you're different from everybody else at this table in as much as you work in a sometimes theatrical environment where we know that some parties in particular will play politics with a particular issue in order to get headlines from it. You guys do it too. Everybody does it. You may not do it on this issue, but everybody does it. How do you take that out of the equation here so that people can just focus on, as Nicole says, the context, the facts, and not so much of the theater?
That's really my point, Steve, because if you talk about the Zamir case, the Premier and the Mayor at the time both made public statements after the incident happened, and they were wrong. Politicians should not be commenting on matters before the courts.
John Tory did apologize for that.
I know he did on that, and I have the utmost respect for John Tory. But it just shows the danger. I mean, the difference between politicians and lawyers is lawyers like to have all the facts before they give an opinion. Politicians don't. And that's acceptable in some circumstances. It's part of the political, world. But when it comes to law and order issues, it's a very dangerous approach to things because it distorts the truth, it distorts the facts, and it creates the impression with the public that things aren't really the way they are. So people need to, dial it back. We need to have a dialogue back to what we were talking about earlier between all of the parties and all of the stakeholders and try to find a system that works. I believe the federal government has done a very good job with respect to these bail reforms since I've been in office in 2015. Bill C-48, which came into effect just under a year ago now. It'll be 12 months in a couple days. Was a result of consultation with provinces, with police associations, with different stakeholders, and everybody bought into it.
What kind of difference do you think it's made?
Well, it's probably a little bit early to answer that question. I mean, it's only been a year, but back to the political rhetoric piece. I mean, because that's the one and only piece of legislation the federal conservatives ever supported, and that was only because Pierre Poilievre sort of boxed himself in because after he became a leader in the summer, he went public. He was on a news program and said, "I'll pass that bill tomorrow." So when we went to the House in September, he said, "Okay, let's pass it today." It took a couple of days, but he'd sort of cornered himself. And now they've turned around since then, and they've been criticizing that very legislation, which they support and endorse. So how is that constructive when we haven't had an opportunity to sort of digest it and see how it's had an impact on the system? It doesn't help, and this is the kind of thing we need to dial back.
C-48's been in for a year. Can you tell if it's working better now?
Well, Steve, I think it's a little bit early to tell. I mean, it's just under a year since it received royal assent. But the important thing to look at, I think, is going back to the rhetoric point I was making earlier. This bill is the only bill that was received the support of the opposition Conservatives, and that was because Pierre Poilievre sort of boxed himself in to a position publicly that he then had to follow through with in the House of Commons. But ever since the bill was passed, and keep in mind, this bill was done in consultation with all levels of government, including the provincial government, police associations, all other stakeholders who all endorsed it wholeheartedly. But immediately, almost immediately after the bill was passed, it's received criticism from the opposition, which just goes to show you that there's a lack of sincerity when it comes to having discussions politically about bail reform. And frankly, you've seen the same thing from the province as well, because they've been coming out hard on further bail reform, because what they do is every time there's a crime committed that gets public attention, they jump on it and sensationalize it for their own political purposes. And it creates this impression that just simply isn't true about our system.
How do you think the bail reform act's working so far?
Yeah, so it was right around a year ago this time, and we came out and we supported the changes that were made. But what we're seeing since then is we're continuing to see repeat and violent offenders in our communities victimizing folks, and it doesn't seem to be having the desired effect and impact that it did. And I think it's important that this type of bail is a very complex issue, and it's going to take a lot of work to get a system where our communities feel safe and we're protecting the rights of the folks that are accused. But we've got to continue to evaluate that. Yes, it's only been a year, but immediately our members are seeing not much of a change. Folks are still getting bail too easily. Folks are still getting bail too easily that are committing violent repeat offenses. And so those changes doesn't seem to be having the desired effect or the desired impact that we thought it would. We think we need to continue to reevaluate it and continue to make changes.
You want to come back on that?
With all due respect to Mark, I mean, how can you evaluate it if you don't have data? Part of the discussions leading up to the passage of C-48 was a commitment by the provinces, including the province of Ontario, to provide data about bail hearings. We haven't seen that yet. And it goes back to my other point. If they're not willing to sit down and talk to us about this, you can evaluate this all you want by reading articles in the newspaper, but that's not a proper assessment. You need the data. You need to know what happened to these bail hearings. You need to know where the bail hearings are taking place, in Brantford or in Toronto or in Northern Ontario or remote communities. You don't know how the system's working because we don't have the data.
Mark, is your evidence systemic or is it anecdotal?
Certainly anecdotal, but what we can say is that our members that are laying charges, that are in the courthouse, that are going to court, that are seeing offenders being released, re-victimizing our community members are telling us that. Folks in communities are saying that they feel unsafe in their communities. That's still a problem. And so we've got to continue to look at it. I mean, you're right, it's been a year. It's hard to assess all of the data that's been happening for a year, but let's talk to the folks on the ground. Let's talk to the prosecutors. Let's talk to the police officers, talk to the victims.
Okay, you made a point several minutes ago about pretrial credits. You didn't like the fact that people who were incarcerated waiting for their trials were getting credit for time served, and you would like to see that changed. Shakir's got a view on that, which I think we need to hear as well. What's your take?
Yeah, thanks, Steve. I think it's important to understand why pretrial credit exists. So this was the most recent Supreme Court of Canada decision was R.V. Summers that established this. And it exists because the conditions in pretrial detention are frankly horrific, and we're dealing with time served by people who at the time were innocent. So for example, since the Toronto South Detention Centre opened in Ontario, that's a remand facility we have here, there have been 115 cases decrying the conditions of that facility. Judges have talked about people locked down for 2/3 of the 20 months that they have spent in pre-sentence custody. Judges have said that while apparently aware of the judicial concerns raised about the inhumane treatment of offenders, the ministry has seen fit to ignore them. So the notion that individuals who are in these horrific conditions are strategically gaming the system is frankly out to lunch. People are suffering in these facilities, and that's why we're giving them enhanced pretrial credit, and the time they served was time when they had not been convicted of an offense. So if we want to address that issue, let's fix the conditions in our facilities first. We don't have to resort to these sorts of things in order to recognize human rights abuses.
I want to add to that, though, because there's one other reason why we're providing credit. The appropriate level to provide people is 1.5 to 1. If the important piece is that we are trying to acknowledge fairness, that if you get released on bail and you spend that time in the community, you get sentenced to custody, and somebody else does not get released on bail, that if you both were to get the same sentence, you would spend the same total number of nights in custody. Almost nobody serves their full sentence. You're released at the 2/3 point. But any time that's been spent in pretrial detention doesn't count towards that calculation of the 2/3 point. So if we go ahead and remove this kind of credit thing that's been provided, you are now making it that for folks who are not released on bail, folks who are experiencing poverty and mental health issues and challenges with substance use, some of the most marginalized folks in our society are going, we can punish you more because you didn't have the social connections and the ability to be supervised out in the community than if you had been out compared to somebody else on the other side.
But I think, we're talking about folks, first of all, if you go into any courthouse in the province of Ontario right now, there is somebody today in every courthouse that is up for bail, that is in custody, that is seeking to have it remanded. It's because they know that they're accumulating 2-for-1 credit. They have an idea of the sentence that they're looking at, and they're going to extend their time for pre-custody so they can get credit for that when they're sentenced to whatever crime it is that they've committed.
Is that well known in the system?
Are we asking
Yes,
them that question?
this is happening, and defense lawyers do this. This happens in every courthouse. It is well known that that's what happens. The lawyers will tell us that these types of things happen. Accused
it's not
people,
well known to the CCLA, and we did a comprehensive report on this.
Accused folks will say this as well. The other piece to this as well is that, we're talking about, when I'm talking about repeat and violent offenders, some of the most serious crimes, I think the public expects that folks aren't going to be released on bail unless there's a sensible plan to keep the community safe, to prevent reoffending, and to ensure that the accused person is going to make an appearance in court. And far too frequently, those things aren't all
Are those
happening.
reasonable expectations by the community?
There's certainly reasonable expectations, but I think what part of our problem gets to be is we have a volume problem. When we look at how most cases are resolved, 57% of people have all of their charges withdrawn against them. They're never convicted of what we allegedly said they did on the front end. So what this suggests to me is that we're either bringing in a lot of minor things, we're bringing in things that do not have the necessary evidence to support a conviction, or we have decided that this, again, is perhaps minor enough that we could do some kind of a diversionary piece. And so if we can think about other creative ways, how do we respond to more minor level offending so that we can focus our attention on those who are the most risky, those who present those risks? If we have such a volume going through, we're removing the ability of people being able to make well-informed, proper decisions with the necessary information.
Let me just check this with you, because we're hearing the divide here. We can all look at the same glass of water and just see it very different ways. How do you find the sweet spot of compromise here so that everybody comes away content?
Get everybody in the room. Look, Mark has said twice now he's relying on anecdotal information. So let's keep going back to data. Data drives positive outcomes. If he's saying defense attorneys are telling people this, well, it's, they're telling that in the hallways of a courtroom in Brantford and Toronto. That doesn't help anybody achieve goals and work through the system. And it is a structural problem, because if you don't have enough Crown attorneys, if you don't have enough courtroom space, if you don't have enough prison cells to put these people in, this problem only gets worse. And that's when you get into this anecdotal, sensationalistic political rhetoric about we need to have tougher penalties, just put them in jail because that'll solve the problem.
But James,
it doesn't solve the problem.
We probably can't build enough, though, can we? We can never build enough courthouses. We can never have enough Crown attorneys. There's just no end to what you potentially could use.
Sorry to interrupt. Here's the analogy. People need to understand their jurisdictional boundaries here. Everybody knows when they're talking about healthcare that healthcare delivery is a provincial responsibility. So if you can't get a family doctor, if you're sitting for a long time in an ER, or if you're waiting for an MRI, that's because there's a funding issue with the provincial government. But that's going to affect you. The medicine is not the problem. It's the integrity of the system. It's the structural integrity of the system is the problem. The judicial system is exactly the same thing. If you don't have enough courtrooms, and if you don't have enough Crown attorneys, and you don't have enough other facilities, it's not just you and I that's affected, it's all of our neighbors, and it's the entire community. It's all of my constituents in Etobicoke Lakeshore, and that to me is unacceptable, and that's why the province has to step up.
Nicole.
I think the other thing that we also miss is that we have often having conversations about providing more resources and support to police. We're putting more money into Crown attorneys, into creating, hiring more judges. But we're not putting that same kind of money into legal aid to make sure that we're providing the appropriate defense counsel for those who are going through the system. And anyone who is unrepresented going through the court is going to struggle, is going to take a longer piece of time. So if we're going to put more funding into particular areas of the criminal justice system and now acknowledge if there are more officers, we're likely talking more volume coming in, we then have to make sure that the court infrastructure is also equally supported to be able to respond and process those folks through.
The same thing I just said to him, I could say to you. There will never, ever be enough money to handle all of the legal aid that's necessary, right?
Yes. So I'd go back, I guess, to the earlier point about it. We're bringing in a lot of minor stuff that is consuming a huge amount of resources. We cannot keep up with this. We have a capacity and only so many resources to be able to put into this. Where do we want to spend that? I would say we want to be focusing on that which is serious and violent rather than more lower-level pieces. And it's not perfect, but these are choices that have to be made.
Let me give you a concrete proposal that actually might require some resources, but will actually make the system more efficient. Certain provinces in Canada have pre-charge screening. That means before the charge is formally laid, a prosecutor reviews it and determines whether it should proceed through the system. And those jurisdictions, for example, British Columbia, have a far lower withdrawal rate than other jurisdictions because there's not these excessive or unsupported charges clogging up the system. So there's one concrete way.
We don't do that in Ontario?
We don't do that in Ontario. And CCLA has spoken about the merits of doing so. And I think it's something we should seriously consider in this province.
Steve, I think we can have an entire episode on pre-charge consultation for charges. What I can tell you is that on the ground in British Columbia, the police officers that are there, the president of the Canadian Police Association is from Vancouver. I'm on the national board. We've had lots of conversations around. The system isn't working as intended. In Guelph here in Ontario, there's currently a pilot going on. I spoke to an officer just last week about it. Lots and lots of challenges with that program. One example that the officer in Guelph was telling me about is, they arrest someone at night for breaching their curfew, and the Crown will say, well, listen, it's a minor breach charge, and they get released, and they don't follow through with those charges. I think that's a completely different conversation for a whole nother day. I think what we've got to do here is when we're focused on repeat and violent offenders, we've got to make sure that we've got folks are being held in custody if they pose a significant risk to the community. And let's face it, a lot of times when folks are being arrested, there's officers wearing body-worn video. So we're arresting someone that's got a firearm on them. It's captured on the video where the officer finds the firearm on the person as an example. That person is in custody. They should be held in custody, and we should get them a trial quickly. You've talked about resourcing. Certainly, as you've said, there's never going to be enough money to solve all of these problems, and resourcing will always be an issue, as it will in every aspect of what we're talking about. But I think having folks that are charged with serious violent offenses that pose significant risk to the community, they need to stop being released. Let's hold them in custody. Let's get them an expedient trial, and they can have their day in court.
They say politics is the art of the possible. So we just went through this a year ago, right? We just got the new C-48 a year ago. When can you imagine, particularly given what all is going on in Ottawa these days, when can you imagine a consensus of people coming together saying now is the time to reopen this and make some more changes?
Sorry, did you say a consensus in Ottawa?
That was silly of me to say, wasn't it?
Yeah. Look, it comes down to, and I'm going to go back to Mark's point earlier and take a little bit of issue with what you said, Steve, when it comes, there'll never be enough resources. That's not a good enough answer for me, because when it comes to public safety and making sure that my constituents in Etobicoke Lakeshore are safe, I'm not going to accept that ever, because that's just not good enough. I want Mark to come on this show next time and talk about how the police have enough resources. Bill Blair, who's my colleague and our Minister of Defense, when he was the Chief of Police about 12 years ago, there are 700 less police officers in the City of Toronto now than there were when he was the Chief. That is unacceptable. And saying there isn't enough resources isn't good enough for me. We need to address this, and we need to address, but to Mark's point about repeat violent offenders, and this is where we'll part company a little bit again, what you're seeing is some of the bail laws that exist. The repeat violent offenders, the really bad guys, they aren't getting out on bail. It's the laws that have been changed were things to codify decisions from the Supreme Court of Canada to address things like systemic discrimination and whatnot. And let me end with this. There isn't a single person. I get sick and tired, and back to your point about getting a consensus in Ottawa, of people saying you're soft on crime and this and that. Anybody's going to look me in the eye and tell me I want bad guys walking around my streets is either doesn't know me or is not telling the truth. And I think that goes for everybody. And that's why politicians have to stop doing this. They have to dial back the rhetoric. They have to sit down, accept responsibility. Here's another example, and I'm sorry for going on too long, but I'm very passionate about this. The auto theft issue. For years, I would sit down with auto manufacturers saying, surely to God, you guys can do something to make it harder to steal cars. It's the police. They have to step up and do more. You'd sit with the police. Oh, it's the audio manufacturers, or it's the insurance companies, or it's somebody else. So you put them all in a room and say, okay, now you say that to him and you say that to her, and see what they say back to you. And we did that, and what have we seen? We've seen some constructive outcomes. Auto theft is actually on the way down. There's been measures taken and steps introduced by all levels of government, and the police now have resources available to them to address some of these. There's still a ways to go, but that's how you do it. You don't do it by sending out tweets and jumping on the political rhetoric bandwagon.
I'll give you the last word. We're down to our last 30 seconds.
Yeah, I just want to point out the problem of policy by anecdote, and I think we've heard that here. We're talking about data on this side, numbers, statistics, pre-charge screening, people detained, and we hear, well, I've heard this story or I've heard that story. There was an incident a few weeks ago where some individuals were arrested for firearm offenses that occurred around Queen and Sudbury streets in Toronto. And just a few weeks after that, after all the tweets and people are out on bail and all the rest of it, a high number of those firearm charges were withdrawn. So those people weren't going to face those charges anymore because there wasn't adequate evidence. If we truly share the goal of public safety, which from the CCLA's perspective we do, it's important that we look at the data and make decisions that are going to protect all of us, for those who are protected by these rights and for individuals who want to ensure that they and their families are safe. That's what we stand for.
Can I ask our director to give us, perfect, that was the shot I was looking for, a wide shot so I can thank all of you for coming from near and far to be with us here on TVO tonight for a very good discussion. Thanks so much, everybody.
Thank you.
Thank you.
Thank you.
What does it mean to be stateless? And how can a person end up as a citizen of nowhere? Author Jamie Cha-Yun Liu explores these questions in her new book, Ghost Citizens, Decolonial Apparitions of Stateless, Foreign, and Wayward Figures in Law. She's also a professor of law at the University of Ottawa, and she joins us in studio for more. Hello, Jamie.
Hi.
Thank you so much for joining us in studio. Let's start off right off the bat with a definition. What is a ghost citizen?
A ghost citizen is a term I use to describe stateless people without citizenship to any country whatsoever, who live in a country that they consider their home, but for whatever reason, they aren't able to get the legal documentation or the confirmation that they are citizens of the place that they reside in.
I think for a lot of Canadians and Ontarians, the idea of being born in a place and not having citizenship or paperwork associated might be mind-boggling for them. How does a person become stateless?
In various ways. So people can become stateless by virtue of just not having registered their birth. In some countries, you don't get citizenship by being born in territories, but you have to prove that you meet the requirements, such as you have a parent or a guardian that is a citizenship, has citizenship in that country. Mm-hmm. So some people might lose it because they aren't able to establish that they have the requirements or the links, or they might have lost documentation. Some tragic stories about documents getting lost in the shuffle over generations of people, or just having a fire in their home and losing very important documentation. So there's a variety of ways in which people become stateless.
All right, I want to read a little excerpt from your book. It reads, some parents have not told their children that they are stateless for fear of how it would affect their mental health or their interactions with others in their community. Further, stateless persons recounted their experiences through tears, regret, and frustration, asking why they could not be treated like a community member or a fellow human being. They invariably expressed their surprise when they were treated like a foreigner or as someone who has committed fraud. So help us understand this. So not all stateless people know they're stateless.
Yeah.
How does that come to be?
A huge proportion of stateless people around the world are children because they're born and are not given citizenship by the country of their birth, or their parents aren't able to register or obtain citizenship for them. And many of the parents that I've talked to in my research told me that they understand what it would do to a child because of the stress they themselves feel in terms of trying to access things like education, healthcare, and other services for their children. And they don't want their children to have to feel different or experience any bullying or backlash from that lack of citizenship. And so their parents, guard that information and, if possible, try to help them navigate the world. But it usually hits a snag at some point because, children grow, as you know, and need to access things on their own. And it's sometimes become a very tragic story about how children learn that they have become stateless as a result of, I would say errors or badly structured laws.
Well, let's talk about it. You talk about the role of parents. I want to talk about the role of government. The term gaslighting has become very popular recently, but you use it to refer to states and their stateless residents. In your view, how are governments gaslighting stateless people?
Yeah, there's, the title of my book, Ghost Citizens, really kind of encapsulates the major findings of my research, which is the first thing is states were kind of ghosting. So many of your listeners or viewers of this show might understand it from the dating scene where somebody just completely cuts off contact or does not respond to any communication from a person that you might have gone on a date with. And so states are doing this to stateless people. People might put in citizenship applications, or they might make queries or ask for assistance from government officials, and they're simply not getting any answers, or they're getting wrong answers, or taking down paths that aren't going to get them citizenship, or they're just being told, listen, you're not of our concern. We're not going to help you because we don't believe you are one of us. So, this term of ghost citizen really encapsulates the experience of people who have been told, you're not one of us, we're not going to help you, we're going to deny you citizenship. And on the flip side, while they're denying and ghosting these people, they're also gaslighting their experience in the sense that they're telling them, you're actually a citizen of elsewhere.
Somewhere else.
You're a foreigner, your citizenship is an issue with another country, and you're not our problem. And it's curious because most people have very weak or tangential links to other countries. And usually the state will point to, well, your mother is a citizen of Thailand, of China, other countries. And this is absent any evidence that they are eligible or have been conferred citizenship elsewhere.
Very interesting. You have a personal connection to this issue because of your father. Can you tell us a little bit about his story?
Yeah, my father was born stateless. He was born in a country called Brunei, and he was stateless for the first 25 years of his life, I would say. And, it affected him profoundly. He used to tell me when I was younger that he was stateless and how it made him feel, how he, was denied opportunities for further education. It really shaped his decisions in his life. I think it also affected his mental health. And when I was younger, I used to think it was a really strange and unique story. But when I became a lawyer and started to see clients who were also stateless, and then when I became a legal scholar, I started to read the immense body of work that started to emerge around who are stateless and how they become stateless. I began to realize that my dad's story is quite typical and started to investigate it myself. And I think, one of the lessons that I've learned from my dad is that I think it's important to talk about it. Like, he was very open about it with me, which is very unusual for Asian parents. And in fact, a lot of people in my family who migrated to Canada to become citizens can't talk about it today. The trauma of being stateless really has prevented them from being able to do so. And so I feel duty-bound to share our story, to create more awareness around the situation, and to say that it is not a strange, unique, or uncommon, and that there needs to be more attention paid to how we can resolve this issue.
Was there, I'm just curious, was there a little bit of shame? I know you said that your father was open about it with you, but, having this secret, this open secret within your family, did you growing up feel a little shame of that?
For sure. I felt like I was very different from other Asian families. You hear their migration stories or why they came to Canada or how they came to Canada, and mine was very different. And so Personally, I did feel that. I'm sure my father felt that too, and then the ways he talks about it, I think he felt like he was treated less than human, subhuman. He used those words that, he felt like he was rightsless. So it can have a profound impact on the way that people see themselves and the way that they might interact with the world.
So in that particular example with your father, born in Brunei, but what was his paperwork saying that he was from when we talk about that gaslighting?
Yeah, so his paperwork just said that he was a subject, a British protected subject, but it was, for many people who have traced British colonization and their modes of categorizing people and the ways in which they counted and conducted their census, there are categories of British subjects in law, and being a British subject didn't necessarily mean you were entitled to British citizenship or citizenship of the colony that you were in. And I think, countries like Brunei and Malaysia, the subject of my book, they inherited and incorporated the vestiges of colonial law and the ideas around hierarchies of citizenship. And so my father's story is really born out of a colonial history about the ways in which the British came, divided and separated people and categorized them, and then gave them different ideas of citizenship that have really permeated in many post-British colonial states today.
I'm curious, before we dive into the main research of your book in Malaysia, you had talked about 10 million. You referenced 10 million stateless people, many of them children. I'm curious, do we actually have confidence in that figure? Is that number smaller? Is that number bigger? Where are we getting that information data?
Yeah, that number comes from the United Nations, and it's an estimate, and they themselves don't really know the number. And the reason for that is because stateless people don't necessarily want to be counted or known to the government, because they could be detained, they could be deported to countries they've never been to. That's happened to stateless people. So the risk of coming out or being known to a government to be counted is severe, and stateless people know this, and in order to survive they kind of sometimes have to work behind the scenes or hide in the shadows, which feeds into why I use the term ghost citizen too. A lot of stateless people survive by passing through life in a ghost-like existence. So we don't really know the numbers, and my estimate is that it's much higher because of the fears and the repercussions that stateless people experience.
All right. You conducted, as you mentioned, your research for this book in Malaysia. We have a map to remind people what area of the world we're talking about. The highlighted portion here shows the two land masses that make up Malaysia, partly on the Malaya Peninsula and partly on the island of Borneo on the left over there. Why is Malaysia the right place to study this issue? Because you would think that Brunei would be the place that you would start your research, but there's some challenges there. But why Malaysia?
Yeah, I did initially want to go to Brunei, the place of my father's birth, to study this, but Brunei is not a democratic country. When I went there, there were a lot of people who told me that they were fearful of speaking openly about this issue for fear of repercussions from the Sultan of Brunei and his government there. And I completely understand that. But, my mother was born in Malaysia. I have family there. And I went there and found a vibrant advocacy network of stateless persons and lawyers, paralegals, NGOs that were working to help stateless people there. And so one of the other reasons was that Malaysia is very similar to other countries where there are large populations of stateless people. For example, a lot of post-British colonial states feature a lot of the same legal frameworks, administrative government structures that contribute to the creation and maintenance of statelessness. And so I feel like Malaysia is a nice case study upon which you could kind of take, my framing of ghost citizens and implant it on other countries to test whether or not these same modes and practices that governments are issuing against stateless people in the same ways.
You write, Canada is normalizing citizenship deprivation resulting in cases of statelessness. Can you explain what that means?
Yeah, so Canada is not immune from creating and maintaining statelessness in our borders. There are some very troubling cases where some people have been made stateless because they've been found inadmissible to Canada and therefore undeserving or unworthy due to, being in conflict with the law or engaging in
There's some pretty big cases with
criminal-
the Supreme Court. That,
Yes. And criminal behavior. But also I would say, more troubling is in the refugee law field where people have come to seek asylum and yet, our decision makers don't really grapple or understand that statelessness in and of itself could be a factor or a reason why people should be seeking asylum. And our laws are not built to provide accommodations for stateless people in order for them to obtain status and to become regular members of our society.
All right. I want to read another excerpt from your book. It reads, my father often said his early life as a stateless person was a purgatory. Like him, many stateless people experience an administrative death, be it at birth, at a government counter later in life, or during an encounter with police or other state authorities. Stateless persons avoid the notice of governments when they work under the table to avoid detention and possible deportation. But at other times, they want to be seen. For example, when they need healthcare, education, employment, housing, and belonging. You had mentioned a little bit about growing up and the need for that as well. Can you explain the concept of administrative death?
Yeah, I think it's one of the most interesting findings of my research is that I shadowed people going to a government counter to ask for help, to ask for forms. And in Malaysia, some people were outright denied even a form. And in Malaysia, you need a particular form to apply for citizenship. It has its own serial number. So each form is unique on its own. And so you couldn't just photocopy a form once you got one to give to people. So witnessing how the government authorities were actively denying people access to forms, giving wrong information. I saw paralegals and lawyers quote constitutional provisions in order to lobby government officials to obtain information and forms for their clients. So it's not for the faint of heart in order for some to be able to get access to the very services that we expect governments to issue towards people within their borders, right?
I'm curious, how do stateless people balance the need to be undetected by their governments with the desire to be seen and recognized by them?
Yeah, I think more and more stateless people feel that public advocacy has been a method to resolve their statelessness. I followed one particular woman who was able to resolve her statelessness, and she used public advocacy quite well. She was very articulate. She was, and her case was very sad because her administrative death happened at a government counter when a government official told her, you don't look like a citizen. Right. We're going to look at your birth certificate, which lists your citizenship, and they revoked it. And so there's a lot of, informal decisions made at the government counter that have substantive impacts. And I think when those things happen, stateless people find it cathartic to talk about it in the public, but also might be able to gain public attention and sympathy in order to resolve their individual cases. Having said that, it doesn't really lead to wholesale or systemic change in the system.
I'm curious about the role of international law and human rights regimes when it comes to stateless people. What can they do? Because there's lots of conventions, whether states adhere to them is a whole other thing. But yeah, what is the role?
Yeah, so one role that international law can play is, it already recognizes that there are stateless people. It recognizes that status. However, it gives a lot of prerogative power to states, like a veto power, to say we get to decide who our members are. I'd love to see a pushback in the international community with regards to the power that's given states to just deny wholesale this very powerful role in recognizing people and giving identification or legal existence, really. So, a rethinking about the ways in which we organize our communities and how people should be recognized as part of our community.
We have a few minutes left. I have a couple questions. You also use the term ghost citizens to refer to how myths about stateless people are haunting. Can you expand on that for us a little?
Yeah, I think it's very apropos to our times right now and the ways in which there's a lot of fear about, people who we may not understand are migrating, moving within our borders, and even people who are within our communities but somehow don't have the right status to be able to live like we do. So I think, the term ghost citizen really fuels and highlights the experience that some people experience in terms of how they're being described in the public. So some of them were described as foreigners and when they didn't feel like they were foreigners. Some people are described as terrorists, as criminals, as fraudsters for trying to cheat the system. These are very common words that we see in the public domain in terms of how we talk about different racialized, predominantly groups of people in many parts of the world today. And so, part of the research is a plea to kind of take a step back and say, before we use those terms, who are we really talking about? Are those fair to be using given the challenges that the state and the legal framework has put in front of them?
All right, so let's say we have the ears of some very powerful people. What should be done to improve the lives of stateless people, both in Malaysia, for example, or here in Canada?
Yeah, in Malaysia, there's been some troubling developments where there have been moves to try to amend the constitution to, create more statelessness. So I would say, hopefully, politicians there are looking at ways to reduce statelessness rather than, to close up the border, so to speak. And here in Canada, I guess I would say, to really humanize the people behind the stories that we hear. There's so much fear and, I guess, misunderstanding behind who are the people that are applying for status in Canada, for citizenship, and not to assume they're not from here, not to assume that they aren't, don't have a genuine or authentic connection to Canada. And I think, really need to rethink ways in which we recognize who are members of our society and, more importantly, how we treat people on a more compassionate and human level.
Jamie, we're going to leave it there. I want to thank you so much for coming in and for your work as well.
Thank you so much for having me. It was such a pleasure.
And that is the agenda for Monday, January 6, 2025. Tomorrow on the program, we look at the pending departure of Justin Trudeau. Plus, what if, as Donald Trump suggests, Canada did become the 51st state? We will explore that. I'm Steve Paikin. Thanks for watching TVO, for joining us online at tvo.org, and we'll see you again tomorrow.
The Agenda with Steve Paikin is made possible through generous philanthropic contributions from viewers like you. Thank you for supporting TVO's journalism.